City of Chicago expanding their lawsuits against Glock, while the state of Illinois faces a collection of lawsuits in the Illinois Court of Claims about how they had lapses concerning clear and present danger reports heading into the Highland Park shooting back in 2022. It is Illinois in Focus Daily. I'm Greg Bishop here with the Center Square. Subscribe to America's Talking Network. Click that notification bell and get these morning updates each and every weekday morning. So obviously, Illinois gun legislation leading to litigation on a variety of fronts. We've got the gun ban challenge that's in the Southern District of Illinois Federal Court. Judge Stephen McGlynn is set to have a bench trial on September 16th. We will definitely be there to cover that for you. So like, subscribe, hit that notification bell. Follow me anywhere. Just search Bishop on Air on X, on Facebook, and elsewhere. But wake up each morning here with America's Talking Network. So you've got the City of Chicago expanding their lawsuit against Glock, going to the gun control group Everytown. They post on their website, Chicago expands lawsuit, seeks to hold Glock parent company and local gun dealers accountable for their role, as they say, endangering the city through the sale and marketing of easily modified Glocks. So the City of Chicago versus Glock Inc., and so on. And they've even got a news statement here, first filed in March of 2024. The city's lawsuit alleges that Glock unreasonably endangers Chicagoans by manufacturing semi-automatic pistols in such a way that they can easily convert into machine guns in a matter of minutes with a cheap quarter-sized device called an auto sear. This illegal conversion allows the pistols to fire at a rate as fast as or faster than many U.S. military fully automatic firearms and machine guns. Although auto sears are not manufactured by Glock, they are frequently used on Glocks that they are commonly known as Glock switches and often have the Glock logo on them. Again, not made by Glock. The lawsuit alleges that the design of Glock's handguns, unlike other popular handguns, make them uniquely susceptible to easy modification to allow for automatic fire, despite knowing for decades about the dangers and that Glock could take responsible steps to fix the problem. Glock has chosen not to in order to maximize sales and profits. So it goes on. Again, this is a case up in Chicago that they sued Glock over this. And what's the next steps here? If you go to the Cook County Circuit Clerk's website, you can search for this particular case and pulling this up. If you go to, again, the Cook County Clerk's office and search for the Chancery Division, take the case number, search for that, and then we'll just pull up just to see where we're at with the next steps here. And it says that future court activity, there's going to be a case management call on November 20th. So months from now, this is still being dealt with. But you've got the case that ultimately is allowing for this to move forward. The law that's allowing for this to move forward, that law that Governor Pritzker signed last summer, that allows for individuals and government actors to go after the firearms industry, and that law was signed, and it's currently being challenged in federal court, where you've got the lawsuit filed, and then months later you had the city of Chicago sue Glock using that law, and then you had the plaintiffs in this case say, look, they're using this law to go after bad actors, when previously, again, case filed, start that over, the law was passed, the gun industry sued the state said nobody's been injured by this, so this case should be dismissed, and then Chicago comes in, sues Glock, and then the plaintiffs in the case say, actually, look, you've got a case where Glock is being sued. The firearms industry is being sued. And I'm pulling up the case management for that particular case from the National Shooting Sports Foundation versus Illinois Attorney General Kwame Raoul. And we'll see what the latest docket entry is here. Just finishing up some parameters so we can keep you updated on where this case ultimately is. and maybe what some of the next steps are. So pulling up the docket here from the federal courts. It looks like earlier this month, there was a granting, reviewing parties submitted a joint report of proposed scheduling, a discovery order. Given the nature of the claims asserted by the pending motions for preliminary injunction and dismissal, the parties' obligation to submit a detailed proposed schedule and discovery order is in accordance with the court's June 7th order. It stayed pending a ruling and affirmation pending motions. Scheduling conference set for July 22nd, which is canceled. So that was a couple of days ago. It's canceled. So I guess we'll have to see when they're going to have yet another hearing on this, a case management hearing. So that case is clearly ongoing. But that's not the only litigation there is against the issue of the overall gun debate. And again, you've got the case in the Southern District challenging the state's gun and magazine ban. You've got the case challenging the state's law that allows for actors to go after the gun industry for allegedly making the community less safe, and the subsequent Chicago lawsuit against Glock and several gun owners. So those cases are ongoing, plus the federal cases concerning the FOID card and where those are. Let me see if I can pull that up for you really quick to keep you updated here. The Myers v. Kelly case, which challenges the state's FOID card system. That was filed last year. And then you had a couple of other movements in that case. It was two-part. One dealt with the FOID card constitutionality. Another one dealt with the state's law that requires cases to be filed in Sangamon County or in Cook County if it's a state level case. But looking at the Myers v. Kelly case, you've got a docket entry here from late last month. Status conference set for early July was canceled. It will be reset at a later date. So again, still no real movement on that challenge of the FOID card. But again, it's not those challenges that are only out there challenging the state's laws. You've got public radio and the Chicago Sun-Times reporting that Highland Park parade mass shooting victims are suing Illinois State Police in the Illinois Court of Claims for approving the suspect's gun card. Background on this, July 4th, 2022, Highland Park, suspect gets on a rooftop and shoots and kills people. I mean, dozens of people injured, scores of people killed, victims, survivors, and such. And this was just a horribly tragic event, and ultimately that led to the state's gun and magazine ban. But it was also revealed by local police in the subsequent news conferences when questions were asked about the firearm and the suspect that they had apprehended, and how that suspect got that firearm. Local police shared with the media, that it was an individual that police were aware of. All the way back in 2019, they had a call that they responded to of the suspect in this case as a teenager, possibly having suicidal thoughts. They came to the location. They checked. They also had a separate call around that time where they were called to the house for the suspect being dangerous. And he had knives on him, and then local police, they actually filed a clear and present danger report to Illinois State Police. With Illinois having a firearm owner identification card, if you have red flags like a clear and present danger report, you can have your FOID card revoked or suspended. So Illinois State Police were in receipt of this clear and present danger report of Robert Cremo III, the suspect in this case, still facing trial. So that's a whole saga that's going on. But despite that clear and present danger report, Robert Cremo III's father signed off for Cremo to get a firearm owner identification card. And he applied, and Illinois State Police, even though they were in receipt of that clear and present danger report, gave Cremo the FOID card, which he then went and purchased firearms. So Illinois State Police, when they were confronted with this reality, they gave a FOID card to somebody with a clear and present danger report, simply fired back and said that, in other words, nothing actionable on that clear and present danger report. And then they said, we're changing some rules internally to make sure that these clear and present danger reports are clearly monitored. But you've got in the Court of Claims now 5 different lawsuits. Chicago Sun-Times and WBEZ reporting the lawsuits dispute, saying the alert prompted by the police house call included details that showed Cremo was not fit to obtain guns. The atrocity carried out by Robert Cremo III was predictable and preventable if only Illinois State Police and Firearm Service Bureau had followed their internal rules, laws, and code provisions that applied to dangerous individuals like Robert Cremo III, according to the lawsuit filed on behalf of one individual who died in that shooting. This is something we'll hear a lot more about. I'm going to dig a little bit further, but last week, Illinois State Police Director Brendan Kelly, not specifically about the Highland Park case, but he talked about the clear and present danger reporting and what Illinois State Police does with those types of reports or other types of red flag reports. Again, here's Illinois State Police Director Brendan Kelly last week with the City Club of Chicago.
We've had tremendous success on a number of fronts, not just the universal background check solution that we came up with, but also the tremendous progress we've made when it comes to clear and present danger, more enforcement of firearms restraining orders, getting resources to local law enforcement, not just the state police, to be able to enforce these laws. So there's a whole host of things that have become a reality and that we're doing on a daily basis. Just from June of last year to June of this year, over 11,000 reports of clear and present dangers have been submitted to the Illinois State Police from local law enforcement, from schools, from mental health officials, and in reviewing those, 10,000 of those were founded. And that there was evidence, there was enough information to say that this person was a danger and met the threshold for the statute. And that resulted in thousands of revocations, that resulted in thousands of individuals being denied the ability to get a firearm. The firearms F-tip program, when someone tries to purchase a firearm, over 15,000 of those last year. So if you start to add those numbers up, just in a year time frame, the laws in the state of Illinois that are trying to protect people and trying to make sure that we don't put guns in the hands of people who shouldn't have them, that's over 25,000 times that we've done that just in the past year. So these things are real, they make a difference, and it just takes a lot of enforcement and effort.
So again, Brendan Kelly from Illinois State Police talking about what he says are successes in moving forward to take firearm owner identification cards away from individuals who may have clear and present danger reports or other types of red flag reports. But again, the Highland Park families, the survivors of those shot and killed, suing the state of Illinois because they failed to use a clear and present danger report from local police against the Highland Park suspect and giving him a firearm owner identification card, which he then was able to purchase a gun and allegedly carry out those atrocious shootings in Highland Park on Independence Day in 2022, which, again, that horrible event led to legislators stepping up and passing a gun and magazine ban. So a lot to be said about that. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Join us each and every weekday morning as we break down some of the latest things happening in the state of Illinois to keep you going with your morning. Illinois in Focus Daily with America's Talking Network and the Center Square.